Exclusions. In this video we will explore the types of school exclusions, you and your child and young person's rights around school exclusions, appealing a decision to exclude your child or young person. What is exclusion? Exclusion is the formal sending home of a student from school for disciplinary reasons. An exclusion can be fixed term, temporary or permanent. A student is not allowed in school while they are excluded. All maintained mainstream and special schools, including academies, must follow the government's statutory guidance on exclusions. This guidance does not cover further education colleges or independent schools, as they have their own exclusion procedures. This video will only cover exclusions in maintained schools and pupil referral units. All schools must have a behaviour policy setting out the school rules and the consequences if a student breaks the rules, which must include circumstances where an exclusion might be used. In some situations, a student can be excluded for behaviour outside of the school. Exclusions may be for a series of incidents or for a more serious one-off incident. The decision to exclude. Exclusion must be lawful, reasonable and fair. Only the head teacher or acting head can make the decision to exclude your child, and the exclusion must be for the disciplinary reasons only. For example, it is not lawful to exclude someone because the school cannot meet that person's or that pupil's special educational needs, or for low attainment, or for a parent's behaviour. Before making the decision, the head teachers should consider the views of those involved. Where possible, they should give you, your child or young person a chance to present their case. The head can apply the balance of probabilities. Is the student more likely to have done what they have been accused of? Other factors should be considered. For example, is the incident a response to bullying? Or are there family difficulties affecting a student's behaviour? Exclusion of children with special education needs and/or a disability. The head can exclude a student even if they have SEN or a disability. However, if the behaviour is related to a child's SEN or disability, the school should first try and take action to identify and address the underlying cause of their behaviour. For example, the school could increase SEN support or pastoral support, seek specialist advice from services such as a behavioural or education psychology team, request an EHC needs assessment, or arrange emergency annual review if there's a current EHC plan in place. In some cases, excluding a student for behaviour relating to their disability could be discrimination. Exclusion should be a last resort. Under the Equality Act 2010, schools must make reasonable adjustment for disabled pupils. For example, the school might change its behaviour policy so it doesn't treat disabled pupils in the same way as any others by punishing them with an exclusion. Alternatives to exclusions. The school's behaviour policy should set out alternatives to exclusions. Disciplinary measures will depend on the school, but they may include detention, being taught in a separate room within the school, a managed move to another school, either on a trial or permanent basis, temporary attendance in other education centre to help improve behaviour. The procedure when a child or young person is excluded. You must be told without delay about the exclusion. The school would usually ring you first, but they may also write to you straight away. This can be sent by letter or electronically. The written information must include the reason for the exclusion, the length of the exclusion, the number of days if fixed term or if this is a permanent exclusion, information about how you can challenge the exclusion, and the responsibility to make sure your child or young person is not in a public place during the school hours for at least the first 5 days of the exclusion. Also, any arrangements for the alternative provision. The school must always provide this information in writing if they are sending your child home for disciplinary reasons, even if the exclusion is very short. It is not lawful for the school just to tell you to take your child home without recording this as a formal exclusion. Fixed term exclusions. A school can exclude for a set number of days up to a maximum of 45 days in a school year. A lunchtime exclusion counts as half a day. When the exclusion has ended, your child or young person must be allowed back to school. The head teacher cannot extend an exclusion, but they may issue a new fixed term or permanent exclusion to begin straight after the first. This should only be done in exceptional circumstances, for example if new information has come to light. The school should invite you and your child or young person to a meeting on the day your child returns to school. However, your child must still be allowed to come back to school even if you cannot attend that meeting. Your child's education during fixed term exclusions. During the first 5 days of an exclusion, the school should take out reasonable steps to set and mark work for your child or young person. For longer exclusions, the school must arrange suitable full-time alternative education to begin from the 6th day of the exclusion. This may be in a pupil referral unit, a PRU. Challenging a fixed term exclusion. For all exclusions, you can put your views in writing to the school governors. This is called making representations. The governors have the power to decide whether the head teacher made the right decision. In some cases, they can overturn the exclusion and reinstate your child or young person. Permanent exclusion. A permanent exclusion should be issued only in response to a serious breach of persistent breaches of the school and behaviour policy, and when allowing the pupil to remain in school would seriously harm the education or welfare of that student or others within the school. Your child's education during a permanent exclusion. During the first 5 days of an exclusion, the school should take reasonable steps to set and mark work for your child or young person. From the 6th day, the local authority must arrange suitable alternative education for your child or young person. This may be in the pupil referral unit, PRU. In the longer term, the local authority should find a place in another school for your child or young person. You can also apply to other schools. However, a school can refuse to accept a child if they have been permanently excluded twice already within the last 2 years. And in some circumstances, they can refuse students with challenging behaviour. If your child has an education, health and care plan, an exclusion or the threat of one should trigger an emergency review of the plan. The local authority must make sure that any alternative provision is able to meet your child or young person's special education needs as set out in the EHC plan. Challenging a permanent exclusion. The governors must meet with you within 15 school days to review the exclusion. You will attend the meeting and put your views to the governors. The governors must consider whether the head teacher's decision was lawful, reasonable and fair. They have the power to overturn the exclusion and allow your child or young person back to the school. They can also overturn the exclusion and reinstate your child or young person in principle, even if you do not want your child to return to the school. If the governors agree with the head teacher and uphold the decision, they must write to you and let you know. You have 15 school days from the date of the letter to ask for an independent review panel, an IRP, to consider the exclusion. The governing body must ask for any written evidence in advance of the meeting, including witness statements and other information held by the school, such as those relating to a student's special educational needs. They must circulate any written evidence and information, including a list of who will be present, to all parties at least 5 school days in advance of the meeting. They must also allow parents and students to be supported to attend the meeting by a friend or a representative. They should also identify the steps they will take to enable and encourage the excluded student to attend the meeting and speak on their own behalf, taking into account the student's age and understanding, and participate by any other means if not attending the meeting isn't an option. The Independent Review Panel. If the governing body upholds a permanent exclusion, parents have the right to request that their decision is reviewed by an Independent Review Panel, an IRP. Parents must lodge their application for review within 15 school days of notice being given to the parents by the governing body of their decision to uphold the permanent exclusion, or when an application has not been made within this time frame, within 15 school days of the final outcome or a claim for disability discrimination under the Equality Act in relation to the exclusion. These are strict deadlines, and any application made outside of the legal time frame must be rejected by the local authority and academy trust. Parents must request an independent review panel even if they did not make a case to or attend the meeting at which the governing body considers the exclusion. Parents must submit written representations and, if applicable, supporting evidence when lodging their application. New evidence can be submitted to the Independent Review Panel. However, when deciding whether to quash the decision, the panel should only take into account the evidence available to the governing body at the time of making the decision, not to reinstate. The local authority or the academy trust must construct the panel with either 3 or 5 members. 1, a lay member to chair the panel. 1 or 2 school governors who have served as a governor for at least 12 consecutive months in the last 5 years, provided they have not been teachers or head teachers during this time, and 1 or 2 head teachers or individuals who have been head teachers within the last 5 years. The role of the panel is to review the governing body's decision not to reinstate a permanently excluded pupil. In reviewing the decision, the panel must consider the interests and the circumstances of the excluded student, including the circumstances in which the student was excluded, and have regard to the interests of other pupils and students and people working within the school. The panel can decide to uphold the exclusion decision, recommend that the governing body reconsiders their decision, or quash the decision and direct that the governing body considers the exclusion again. Can I request a special education needs expert to attend the IRP? Parents have a right to request attendance of a SEN expert at the IRP, regardless of whether the school recognises that the child has SEN. The SEN expert should be a professional with first-hand experience of the assessment and the support of special educational needs, as well as an understanding of the legal requirements on schools in relation to SEN and disability. SEN experts must be impartial. The SEN expert can be employed by another local authority or an academy trust, but they should not have had any previous involvement in the assessment or support of SEN for the excluded student. The purpose of this is to avoid a conflict of interest. The appointment of a SEN expert is for the local authority or academy trust to make, but it should take reasonable steps to ensure that parents have confidence in the impartiality and capability of the SEN expert. Where possible, this may include offering parents a choice of SEN expert. The focus of the SEN expert advice should be on whether the school's policy which relates to SEN or the application of this policy in relation to the excluded students was legal, reasonable and fair. If the SEN expert believes that this was not the case, they should advise the panel on the possible contribution that this could have made to the circumstances of the student's exclusion. Where the school does not recognise that a pupil has SEN, the SEN expert should advise the panel on whether they believe the school acted in a legal, responsible and in a fair way with respect to the identification of any SEN that the pupil may potentially have, and any contribution that this could have made to the circumstances of the pupil being excluded. Legal advice. RIAS can support you to attend the panel if there is an identified special education need. Although we're not able to represent you, your child or young person. For more information about school exclusions, appeals and the IRP, contact Child Law Advice or Just for Kids Law.